Hello friends, welcome to our channel Khatri Steno. Be ready for the dictation. We shall first of all deal with the submission of Mr. Thakur with regard to the junior clerks and class 4 employees of the Supreme Court. The Learned Council has placed much reliance upon the judgments of the Delhi High Court in revising the pay scales of certain categories of Class 3 and Class 4 employees as stated herein before granting the pay scales of rupees 400, 600 and rupees 300 to 430 respectively to LDCs and Class 4 employees. It is submitted that the Delhi High Court was fully empowered under Article 226 of the Constitution to issue appropriate writs if, in its opinion, the recommendations of the Third Pay Commission as adopted by the Government of India and as reflected in the revised pay rules of 1973 insofar as these mulls related to the staff of the Delhi High Court amounted to discrimination and consequently violated Article 14 of the Constitution of India. Council submits that the special leave petitions filed by the government against the judgments of the Delhi High Court having been dismissed by this court, the Delhi High Court judgments revising the pay scales of its employees, including the pay scales of the LDCs and Class 4 employees, have attained finality and operate as res judicata between the parties, namely the employees of the Delhi High Court and the Union of India. It is submitted that this court was fully justified in passing the interim orders on the basis of the judgments of the Delhi High Court, which had become final and conclusive between the parties and binding on them, and that the pay scales granted by this court by the interim orders were consonant to justice and equity. It is urged that it was not open to the Fourth Pay Commission while revising the pay scales of the staff of the Supreme Court to take a pay scale lower than the one prescribed by this court by the interim orders as the basis for revision, as that would amount to negativing and neutralizing the effect of the orders passed by this court. It is submitted by the Learned Council that the recommendations of the Fourth Pay Commission, if allowed to prevail, would result in the reduction of the salaries of the junior clerks and Class 4 employees to a level lower than what they were receiving on the date of the revision, and it would be highly discriminatory and violative of Article 14 of the Constitution. On the other hand, the learned Attorney General, appearing on behalf of the Union of India in the first instance, points out that the Delhi High Court judgments, particularly the judgment in CWP number 1376 of 1984, Shri Kamalanand versus Union of India and others, are based on the doctrine of equal pay for equal work as enshrined in Article 39 within bracket D of the Constitution of India. The learned Attorney General has made elaborate submissions as to the applicability of the said doctrine to the cases of the employees of the Delhi High Court and also of the Supreme Court.